So Lisa, thank you very much for being part of the conference on so many sessions, and obviously some interesting discussions we've had. Let's have another interesting one. So of course,
Thank
you know,
you so
Lisa,
much.
see you, Laura. You know the drill. The drill is that we first have Lisa talking about the conference. That's how it happens. And then we move forward. Yes, LawMom?
Okay.
About the
Yeah.
conference, not about LawMom, not
No,
about the
not
topic.
about, no. It's never about me. It's never about me.
It will be about you. It will be, but
Okay, so this is the World Mediators Conference, which is held annually every year and is kicked off by celebrating our grand man of mediation, Ken Cloak. His birthday is on the 18th of May, so that kicked off this conference as it does every year. And it's been running now for over a month and a half, or just about a month and a half, and it's ending tomorrow. And we've had various people come on board Vikram's revolution, and it's been a fantastic platform for all of us to, from all over the world, to give our thoughts and contribute our little bit to understanding mediation and even challenging aspects of it. So this is the conference, and I've been pleased to be a part of it. It's my first one, and it's my fifth and last session, and I'll be talking about oxymorons in mediation.
great. That's a great introduction, Lisa. Now it's about you. Of course, you've been in so many sessions, but every session is not watched by everyone. So
Yeah.
it has a fresh start. So Lisa, please about yourself, and then we get into the topic.
Okay, so you would have seen my nickname in the poster, Lisa LawMom Thomas. That's my, I guess, my brand on LinkedIn, where I teach and mentor who I call baby lawyers. So they're basically the law students, law graduates, young professionals in the South African legal industry. And I've become a portal resource for them on various levels, mentorship, my academy, and even at introducing them to mediation, which is something that I'm very happy to have been able to start, because I want to get them out of that adversarial mindset. So my activity is mainly on LinkedIn, but I have many irons in the fire and lots of initiatives, basically for skills development and teaching and training in legal stuff, and hopefully getting into the mediation training soon. So that's me, and I'm doing what I love, and it's my passion, and I love working with young people and students. And I'm very pleased to be giving my contribution to this conference.
Great. And that's a lot of contribution. That's all. That's important. And please watch all the sessions. They've all been interesting conversations. So mediation oxymorons, please start it off with mandatory mediation. Please.
Let's start with mandatory mediation. Okay. Okay, let me get the slideshow.
That's a good thing. Lisa comes all prepared and all. I wish I was that I had all this stuff with me.
Okay. Let me give it a bit of introduction first. So,
but can we do a slide share, because the screen slideshow, because
no, I said I want to start it from the beginning. So, but we're going to get to those mandatory, court compelled, all of those things. So
no, I'm just saying, if you do the slideshow, at least we're able to see it a little bigger. That's the only
No, I'm going to start it, but I'm not going to start. My slideshow doesn't start with the mandatory.
Yeah, obviously.
Yeah. So
what happens is, on the phone, it actually looks really small when it's not on slideshow mode. Yes, it's opening up. It takes its time a little bit. Yeah, much better.
Okay. So this is a topic that came up in our initial discussion between Vikram and I. No, actually it was in one of the conference sessions after the session, and it was just all of these things that have been introduced to the process, the mediation process, and all that it stands for, it doesn't go together. And it sort of takes away from the true nature of mediation and the characteristics and the outcomes that are expected, right? So what are oxymorons? Okay, they're not another species. Although in this particular presentation, we might say that the oxymorons actually the judicial morons, right?
Yeah.
Where the court has come into the thing. So they are not another species of morons. Oxymorons are basically the grammatical contradictions or juxtapositions. So where we put two things like that are opposed to each other, like as Vikram said, mandatory mediation. Okay, that doesn't go together if you are a mediation purist and you are true to the process and the nature and its characteristics and its format and all of that, then you would understand that mandatory mediation is an oxymoron, right? It's a mediation oxymoron. Those two terms don't belong together because for the simple reason that the word mandatory takes away from the voluntary nature or the where parties come to the mediation on their own where they want to resolve stuff. So that's starting with that off the bat. Mandatory mediation is that oxymoron in mediation, right? So like I said, oxymoron in mediation are elements that have been introduced which contradicts the nature and characteristics of the mediation process, right? So anything that, and of course it sounds very nice, right? Okay, things like mandatory mediation or, court compelled mediation. It sounds nice. It sounds official. It sounds, it sounds like it carries weight and authority, right? But of course, if you know what the process is about, then you're supposed to ask, hey, what is the court doing? Or who's forcing people to mediate, right? Doesn't that take away from the solution, the quality of the resolution? Right. So these are things that have been introduced that make it sound nice. Makes it sound, like I said, official and weighty. But of course, they don't belong in the mediation process. Those terms do not belong, right? And of course, with me, I am trying to distinguish mediation from court counseling. Okay, what we call what we call mediation in the judicial space is it's actually a hijacking, and I'm going to come to it later in my presentation. It's a hijacking of mediation, so it's not mediation. So the court has been the chief oxymoron. Okay, they have infiltrated mediation. They've adopted it. They put it as part of the judicial process, and it's lost its meaning. It's lost its if you're forcing parties, if you're coercing parties to enter into it, then it's not really mediation anymore. It's actually a judicial process. So the court also wants to facilitate it, right? Where, for example, as my colleague in the previous session, Erin Moynihan, said that in her case, she was advised by the judge to go, to do mediation, or otherwise he's going to hand down a judgment that nobody would like, right? So here we're also talking about where the court is pushing parties. So even if it is a mediation, an independent process, or they referring you to an outside mediator or mediation firm, the court is still directing people. So they're saying, okay, you go there first, and then maybe come back. So the court is also involved in facilitating mediation. And like I mentioned just now, it's removed the voluntary aspect of it, where parties want to come into this because they want to find a solution. It's taken away that freedom what we call, party autonomy, right? Where the parties are the ones that are in charge of the process. And of course, I believe that the parties must be in charge of as many parts of the process as possible. So from, choosing the venue to choosing the mediator to choosing, um, how long it's going to be, that kind of thing. If you remove that part of it, then like I said, it's not mediation anymore, right? Because now you're effectively forcing parties to come to a solution, and then it's not going to be one that they're going to be able or easily want to facilitate on their own, which is what mediation is about. They want to leave that place with something that they've worked on, and they know that it's in their interest that they sort of keep that agreement, right? And of course, the involvement of lawyers and judges. So this is a big one, where we're asking, does a lawyer have to be present? Does a judge have to authorize a mediation for it to be legitimate? Can you have a mediation without a lawyer or what we call a knowledge expert present? How far is the lawyer's role meant to go? And of course, what has become, another, anomaly is that the courts are training the mediators. So where you have to be accredited by maybe the Supreme Court in America or, to be recognized as a mediator. So there again, the court wants to back up. They want to put weight behind the mediator's credibility, right? And a lot of the times it's lawyers that are becoming mediators. And the question there is obviously, can they switch up the mindsets? Can they switch off the lawyer mindset and get into the mediator mindset? Or is it, like I said, is it just one, a situation where there are blurred lines and it's actually a judicial process that we are, calling mediation? So there are all these, there's probably much more, but I just thought of these four: court infiltration, the court facilitation, the removal of voluntariness, and the involvement of judicial officers and lawyers, judges, and such people. So mediation has essentially become what I call a quasi-judicial process. Okay, it's been hijacked, even in South Africa, right? We have the introduction in the High Court, the Superior Court of Rule 41A, that makes mediation compulsory before attempting litigation. And I think last week sometime, the lower courts have had their rules changed to include mediation in the rules of courts. Now, obviously, this is not, if you understand mediation in its truest, pure sense, it's now not mediation if the courts are in it, right? It's become a quasi-judicial process. The court system, legislation, and the court rules have adopted mediation into its infrastructure. So they've sucked it in, right? And there's no distinctness, or there's no separation, no recognition that mediation has its own rules and infrastructure. Okay, which is what we are trying to push in this conference, and even the whole informal nature of the thing, right? That's also an anomaly, that mediation is essentially informal. So if you're introducing a court sanction or introducing a court room or a judge's authorization, then you're not recognizing the informality of it. You just sucked it into the court structure and the judicial or the legal system, and it's now become just another process in the legal system. And of course, there's no need for judicial sanction to validate the mediation process. So mediation has to stand on its own. It has stood on its own for as long as we've been doing it, and for as long as, even before we even knew what we were doing, what our ancestors were doing under the tree, when they would resolve tribal, elders, they'd bring disputes to the tribal elders, and when it was village life and tribal life, and things got sorted out. So we are not craving, and we don't need to be endorsed by the judicial system in any country. In fact, we don't need judicial sanction. We don't need them to put their weight behind the process to validate the process. The process works. It's not a silver bullet. I myself always acknowledge that. Mediation doesn't work in all cases, but it works in most cases. And for that reason, it ought to be attempted, because you never know that you can get something resolved without going to a courtroom and have a much better quality of resolution. So it's always better to try it, and it works. In general, it works. If it doesn't work for one particular case, then it's not a indictment on the entire process, right? Okay, so mediation has now become a mutant. Okay, we've created a hybrid form, which is not mediation. Okay, it's something else. I don't know what it is. All I can call it is a quasi-judicial process. I don't know what it is. Probably akin to court counseling or like a court social worker kind of situation. Okay, that's the closest I can think of right now. But it's become something else within the court system. It's no longer, once it's there, once it's been adopted into that system, it's lost its true form. So it's become sort of, the genes have been messed with, it's been like crossbred with something, it's been crossbred with the judicial system, and it's no longer mediation, right? And it's a hybrid experiment between two opposing processes. Okay, like I said, one is litigation is forced, mediation is voluntary. Mediation is informal, litigation is formal. Okay, the outcome litigation is enforceable in the court, it's enforceable after the fact, and of course, a mediated resolution is facilitated by the parties. You don't need the mediator to come and stamp anything, or there to be any penalty for violating the agreement, right? So it's bound to fail. That's why we're seeing the problems in implementation, especially in the US, where the number of cases that go to mediation, there aren't that many, because people are picking up that, oh, it's just another court thing. Like, I don't see what the process is. And of course, if, as some people have testified, my US colleagues, if there's coercion involved, then of course there's going to be a problem with implementation, because now the parties are not going to feel that they are facilitating, that they are part of the solution. So you can have the mechanism, but the truth of the matter is it's not working. It's not working within the court system, because it's two opposing processes, two oxymoronic processes, right? They cannot go together, right? Because of the nature, because of the essence of the two, and the kinds of outcomes that they produce. You can't put them together. And so the hybridization naturally will lead to a problem in implementation, right? Just like how you crossbreed, species that are too close together, or humans, for example, if there's incest, right? You see the problem if you put things that are too close, or things that are not meant to go together, right? That's my point. You start to see, because the people will have diseases and certain disorders that come from mixing the things up, right? So the court system has definitely taken mediation, and they've definitely contaminated it, and they've made it into something else, right? So now we come to the fun part, okay? It's oxymoronic terminology. So it's what I referred to in my first slide, where we have terms like court annexed mediation. That term is used here, that I'm aware of. Mediation that is attached to the court, right? It's attached to a court process or judicial process. court-imposed mediation, where it's like try mediation or else, right? Court-encouraged mediation, right? Where they're admitting that, our systems are overloaded. Can you just go and try mediation, right? Again, court, right? The court is always a player. And if the court's always a player in it, then it's not mediation, right? Mandatory mediation, okay? Nobody liked the sound of mandatory vaccines, right? Everyone pushed back against mandatory vaccination when it came to COVID. Mandatory mediation is, I think, one of the most moronic of all of the terminology, because it's like saying, it's like describing something, but it looks like something else, right? So you're saying the black cat looks white, kind of thing, right? It's like it's a black cat. It's either black or it's white, right? But you can see it's black. So mandatory mediation is just the most foolhardy concoction. And whether it's used in the judicial setting or outside, I think even, it might even be in mediation circles where it's become accepted. But mandatory mediation is not mediation. It's actually probably forced counseling or forced therapy, maybe. Compelled mediation, again, same thing, where it removes the voluntary thing. So it's very closely tied to court-imposed or court-encouraged, where it's usually you need to go for mediation, otherwise there's going to be litigation, right? And then the parties are like, oh, now we have to do this mediation thing. So immediately off the bat, like they're not going to be invested in it because like the judge is saying, or the magistrate is saying, or the presiding officer is saying, therefore we must do it. It's bound to fail, right? The process is not going to be successful. Okay, oxymoronic characteristics, right? So I said at the beginning that oxymorons in mediation is where these elements are introduced that take away from the characteristics of mediation. Okay, and what we don't want to see, but what is happening is judicial coercion, like I'm saying, compelled mediation, where there's from the bench, from the judge's seats, you guys need to do this, or I'm going to do something else, or the court case is going to continue, or I'm going to make an order that no one's going to like. So everybody has to go. So you have this thing of judicial coercion where and coercion is coercion, okay? Whether it's being done by a judge, or even if someone is coercing you, a lay person is like you're being forced into a mediation. Coercion is never part of the deal, right? So whoever's coercing you, in fact, if you are forced into the thing, then that's something that's opposite to what mediation, the characteristic, right? Of I do it, I have autonomy. I decided I want to go into it because I want a more peaceful process. And of course, I want a solution that's going to work for my situation, right? And of course, the way the court is involved, the process is now involuntary. So it's in the rules. And in fact, if you disobey the rules of the court, here I know, and I've seen it, I've read about it overseas, where if you don't try mediation before, you don't follow the rule, the particular rule, and try mediation before litigating, you're actually penalized with a cost order, right? Or if your reasons for not pursuing mediation where the court didn't think it was sufficient or good enough, one of the parties has to pay legal costs. They get penalized, right? So I mean, that is the extent of, even if you're talking about encouraging lawyers to mediate, they don't want to mediate because they're saying, okay, the rules are forcing us to mediate. And if we don't mediate, we're getting punished. We're getting punished in that we have to pay the other party's legal costs simply because we didn't follow the rules. So again, the whole thing about it being involuntary and making it rules-based within the court system he's not going to even encourage lawyers to go towards mediation because they're going to say, hey, it seems to be like a vicious circle, right? We follow the rules, it doesn't work. We don't follow the rules, we get penalized, right? Then you have re-abused and re-traumatized participants. Okay? A mediation process is not, you're not bringing up the past and sort of thrashing it out because for the sake of being sadistic. The mediator is often, trying to be curious about the situation. And so you have to go into maybe some painful issues, but it's done in a very empathetic way, or it's done in a very, cushioned way, where we're not looking to bring up the past, but we're looking to basically inform the solution or the resolution. Now, in a courts compelled mediation process or whatever it is, you get they are exposed to the harshness of the system, right? And sometimes it can be held in the same building, the same court building, and so you have the setting even of, man, like it's not as sympathetic. Nobody feels sympathetic, or no one feels assured in a court setting or in a court environment, or even in something that's been sanctioned by the court, where the court is asking you to do this. So even if you're going outside, okay, you're not sure how to behave because the court is still behind. And sometimes if it's a court appointed situation or done in the court, there's no sensitivity, there's no handling the cases in a humane, or not that courts are inhumane, but participants in compelled mediation or mandatory mediation, they're often re-abused and re-traumatized. Where if they are wanting to divorce a narcissistic partner, then they find when they are pushed into mediation, instead of divorce, going to the divorce proceedings, then it's like, the whole thing, the wife or the husband who's the victim or the one wanting the divorce, they find themselves re-abused and re-traumatized. And of course, taking your stuff through the system anyway is already re-abusing and re-traumatizing, because sometimes divorce matters are drawn out. Family matters can become lengthy court battles, and it's just, there's no closure. And now if you say, okay, we want you to mediate, but the same thing is happening, then of course that goes against what the process is about. And then enforceability versus facilitated resolution. Okay, if a court is ordering mediation, right, that's something that's an anomaly, right? Because now if you go against the court order, you are in violation. Here you get arrested, and or the sheriff can come to your house, and it's a whole other process, right? And of course, if it's a court facilitated resolution, or court sort of, the mediation is there, it's a part of the court process, then parties are going to be looking to enforce. They're going to be looking to say, okay, you didn't comply with your end of the mediation agreement. So I'm going to go to the police station, for example. Okay. And that's not it. Okay. We're not looking, at the end of the day, the mediation, the resolution must be one that is facilitated by the parties. So everybody has worked towards that. They know it's in their best interest that it be implemented, right? So the mediator is not acting as a policeman to make sure that they are carrying it out. The parties have that understanding that if they carry it out, then it's the harmony will be restored, right? So that's the other thing. Okay, mediation resolutions are not enforced. They are not punished if nobody follows a mediation agreement. Most of the time, or some of the time, it means that, okay, maybe you've got to go back to the mediator and maybe work a bit more on the resolution so that it's better, you're better able to implement it, right? Locations, there's so many factors that can affect the success of a mediation, and there's one location that you want to defeat the purpose of a mediation is a court. Courtroom, a mediation room at court, or even a court-appointed or court-approved mediator or mediation. Okay, so again, this is how the judiciary has infiltrated mediation or has hijacked it so that it now can, for it, and it's kind of insecure, I suppose, because in order for the mediation to be, a court thing, it has to be held at court or in a courtroom or be sanctioned by the court or be done by a court-appointed mediator. And obviously that takes away from, like we're saying, the freedom, the informality, the voluntary aspect of it, the process, right? The whole, where you can be calm, you don't have to worry about, sit up straight. And although mediations do have ground rules, but it's not the same that when you walk into a courtroom or some kind of judicial setting and it's a mediation that's about to happen, you immediately stiffen up, you put your jacket right, and the location definitely does something, and it's definitely going to affect the outcome. So location, right? You cannot have a mediation in a courtroom. Okay, it's like, I guess it's like having, trying to entertain preschoolers in a courtroom. It won't work. Okay, because there's nothing on the walls. It's just wood paneling, and there's no fun pictures and colors, and okay, the environment is not suitable, and those preschoolers or kindergartners will lose interest very quickly, right? So this, you're not going to get the true participation of people as you would get in an informal setting in mediation. So we can't have courtrooms, mediation rooms at court. It's very noble. You kind of get the idea that they want everything to be maybe centralized. But again, mediation doesn't need the centralization of the courtroom, okay? We don't even need a location, right? It happens everywhere, every day, even if you're not a professional, right? You are doing it. So we don't need the courts to sort of sanction or validate or say, come and have it at the court. It must be held at the court. It doesn't validate the process. The process can happen anywhere. Yeah. And then my last slide is, of course, the purest approach to mediation, which is I've identified 3 main points, where we need to protect the process. So for me, I'm trying to preach about, where the court comes in versus what the process actually is. So I, for one, am committed to keeping the processes separate, right? We can give the court hybrid another name, but we cannot call it mediation. Okay, mediation is something that's an entirely different creature, and it cannot be crossbred with the judicial process or the judicial system or the legal system. And you certainly can't enforce mediation through legislation and court rules, right? So I personally am committed to protecting the process because, like I said, it worked. It worked for centuries, possibly for millennia, right? And there's no need to mix it up, contaminate it, and validate it through any other medium, right? And so we have to, I think, wherever we are in our respective countries, we maintain the uniqueness and the separation from the courts. So maybe we support what's going on at the court on, a small level or a micro level or to an extent, but we maintain that that is not mediation. If you want a pure mediation process, you have to go outside the court system. Okay, and of course, I think the courts are probably afraid of, cases not coming to them anymore. So they say, okay, let's just centralize everything in the courts and we keep the cases coming. But of course, we have to maintain the uniqueness and maintain that separation. How we have separation of powers, okay, in governance, in a country's governance structure. We have executive, legislative, and judiciary. Separation of powers, we have to separate. We have to maintain the independence of mediation. Okay, in our country, we pride ourselves on independence of the judiciary, where it's not seemingly not open to interference by the other branches, but it's not realistically what happened. There is interference, but I think we need to maintain the independence of mediation. We need to maintain it and keep it separate from the courts. Okay, and of course, we must emphasize voluntariness. So if people don't want to mediate, it's not for them. Or if they've tried it and it's failed them, then it's probably not our place to force them to try it again. And of course, we must emphasize that if something is being compelled and you've been ordered to do something by someone or by an institution, then that is not mediation. You must be able to want to do it from your heart. And of course, you must want to do it because you want to restore something or a relationship or whatever, right? So we have to emphasize the voluntary aspect of mediation. And then lastly, we have to promote mediation's qualitative outcome over the court's quantitative or penal outcome. So like I was saying about, where the attorneys are getting penalized for not trying mediation or not trying it well enough, right? The court by nature is all about how much of damages you can get, right? And winners and losers, and somebody is being penalized for their conduct or they're being punished, right? So we have to, as far as possible, in the cases that are ripe for it, we have to promote that mediation it's a quality based, it's more qualitative. We are more interested in the quality of the outcome than who wins, who loses, how much are they going to get, how much, whether I'm going to have to pay legal costs, how much legal costs, and who's going to come out with all of the cash at the end, right? That is not a quality outcome. It's about quantity, and it's about one party losing out inevitably and another party gaining, right? And that's not, of course, it's completely opposed to what mediation is about. So for me, personally, I'm interested in, while I will, litigation has its place, but for me, I'm interested in the quality of the outcome that people reach. And of course, a good mediator or a skilled mediator will encourage participants to come to the best quality outcome, because they are the ones that are going to have to implement it when they are no longer in the mediation room or they're in the mediation space, whatever that space is. But if it's a court thing, then if you get a court award in your favor, if the other party that you won against defaults, you're going to go running back to your attorney and say, we need to go arrest this person because they're in violation of the court order. That is not quality. That is just fighting, right? And it's just you're just riling everybody up again, and it's not leading to anything calming down. It's just, it has a potential to blow up over and over again. So that is the purest approach to mediation. The courts must not get involved. And if they do get involved, they need to call it something else. And of course, we need to maintain the separation of mediation and, foster independence in our mediation space. So that's my presentation.
We have to discuss this one, then we have to move on to another oxymoron. But in this one, what we're really discussing is the aspect of the foundation being weak, because you are doing it because you have a self-interest in clearing the backlog, and you're making it more and more absurd. Like you said, if you do not, some countries have this thing saying you did not go into a mediation in good faith. So court will sit and decide whether you went into the mediation in good faith. I mean, come off it. Stay away from that also. First, you want to send people there, and then you want to go into what their intention of going there was. And then after that, there was a reasonable offer you did not take, so you should be penalized for that. How we come off it? This is like, how? What is there an end to judicial intervention? This is more than intervention. This is
No,
interference
yeah,
with its
it's
words.
invasion. I think it's invasion.
Invasion. Yeah.
They hijacking it. Yeah, I think it's, they like to make it academic. So I mean, how do you even, say, okay, that was a reasonable offer? To the parties, it might not have been reasonable. You sitting on at the top and you saying, oh, but it was reasonable. Why didn't you take it? And because you didn't take it now, we're going to penalize you. I mean, it's just perambulating. It's just circling around. Can we actually come to an end of this now? I think they just get so, we want to have the last say kind of thing. And
Yeah.
and it makes mediation almost like a younger brother, like who's always being, shouted down by the older brother, saying, I'm older than you listen to me, I got more experience. So if you don't listen to me, I'm gonna, bully you, or you must do all my chores for me, or whatever. So
Yeah, I mean, in terms of them thinking that in the dispute resolution space, they are the people, and everything else is just secondary. Okay, go do it, but we are the guys who, in terms of that rule dispute resolution, that whole concept has to change. Only then can we move forward. And actually, first of all, the backlog itself can become less, but at least empowerment of the people has to happen. So, yeah, that's an issue. But Lisa, what next of Oxymoron? Which one?
I think it's a whole thing about training as well. Uh, I think the courts mustn't take over that. They don't need to sanction
Yeah,
mediators.
yeah.
Like we don't need like another kind of a degree setup where it's like, oh, I am,
Okay.
accredited, or I'm appointed by the High
Yeah.
Court of South Africa, High Court appointed mediator, like that is in itself like
Court
what kind of
appointed
time?
mediator. Okay. Well, okay. But no, I mean,
Yeah.
what you have to do is let's look at Oxymoron. Like, first of all, even certified mediator. Now, point is that certification of that kind, for me, certification is the user. User certifies you, but you are the mediator. So anyone else certifying, it's like saying we can actually gauge you in terms of your mindset, your mediator mindset, and everything else goes into it. We've understood everything, and now we can, on those parameters, check you. And I think it's a little more involved than that. It is not as easy as you're trying to make it into one boxes that you will tick, and this one, now I can certify this individual. That's saying a lot.
Yeah, we don't need, because even in a law degree, is not making good lawyers. Studying for a degree, it doesn't mean, okay. So you're getting, lawyers getting caught for fraud, lawyers stealing money, lawyers are lying. So what does that even that? And we say, oh, look, he wasted the whole degree because now he's going to get disbarred. Okay, so we're saying certified mediator. Is it just on paper,
And also the
or do
fact
you
is that
actually have you
yeah,
actually have like the skill? Like that's why I think testimonials are so important, because I think if the participants are happy with you, then
and
that is the validation, that is
on
the
each,
approval that you need. Yeah.
and it's on each individual situation, and every time you are actually going to be certified by every process by the people in that process. So that definitely has to happen. But look, I'm saying that the fact that someone says that I've understood everything about what goes into it, and I know now you are someone I can send out into this world, and now you are a mediator. Created you. I'm saying there is, if you understood that much, then you can change so much in the world. If you understood what goes into being that mediator in that situation, I think it's more, like I said, it's more involved than that. But one thing that Lisa, we have to oxymoron that we have to look at is mediation advocacy.
Mm. Yeah. So I,
Let's look at
I
the
think
let's put. I'm putting you on the spot. You didn't take.
mediation advocacy.
Let's put it. What is advocacy? First of all, let's put the meaning up there, and see how mediation advocacy is an oxymoron, right? Okay, so we should start by that.
Okay.
So let's do that. What is it? What is well, let's look it from public support for a recommendation of a particular cause or policy. So in a way, you've created the same environment in a mediation, that I am now on this side, I'm for this cause or for this person, and I'm arguing for this person. The other one is on that side arguing for this person. Is that the way mediation works? If that is the way you think mediation works, then you have not understood the concept of mediation, is what I say. Is it a advocacy, or is it a collaboration or a collaborative approach, or whatever else that you can use words? But advocacy definitely is an issue if you think advocacy is required in mediation.
Yeah, definitely. You can't, but then you might as well just be adversarial.
Exactly. You're
Okay,
bringing the same thing.
you're still in your own corner. So if you're a mediation advocate, then it's like,
Yeah,
what's
no, we don't mind the mediation advocates in the sense, go out and advocate for mediation, say yes, mediation should be
yeah.
used, do that. But in a mediation advocacy, I find it quite, in a way, absurd. And now you have,
I haven't come across it, to be honest. So
oh, people are doing
um,
trainings now. Look, everything happens into trainings. Now people are making money by saying we're going
training.
to train you to be a mediation advocate. So what are we telling you? That there is still a concept of advocacy in the process. It's actually, it should be mediation participant. We are training you to be a participant in the mediation, and how you can take the process through so that it
Yeah,
reaches a solution. That
yeah.
part I can understand. Let's do that, Lisa. Let's have mediation participation training. Everything is training
Participation.
these days.
Yeah.
Yeah, that makes that we can do that. Mediation participation training. Good idea. These are the ideas that come up.
I bet they'll ask us what is that?
With exactly what this is. It's about how
Uh,
do you go about helping people, and this is not just for lawyers. It could
yeah,
be other experts coming in. It could be family members coming in. It could be, it's a wide area of work. So all kinds of mediations take place. So to be a participant in the mediation, you have to first have the mindset that you are a participant. You are not an advocate in the mediation for anyone. I mean, you don't advocate for the people in dispute, you help them in resolving it. So I think that needs to be put out there. So I think this is a good idea. I think these are mediation participation training.
training. Yeah. Know your place.
So anyone who wants to be part of a mediation, be it as a person in dispute, that's I keep saying that you have the category of participants, and it is
Mm,
for me a broader aspect than the people in the dispute. It's a broader aspect than that,
yeah,
because
yeah.
anyone who comes in, okay, you have the mediator. Is the mediator also participant in the thing? Yes, but we've given that mediator a certain role, so we call the person a mediator. But everyone is participating in it because everyone's objective is the same, that a solution comes out of the issue. So why are we not still saying that we are pulling into on two sides, but we still want to go ahead together? It just sounds absurd.
Yeah, yeah. I think I mentioned in that language, changing the language. We got all these terms for people: mediator, parties, disputants. Like everybody is a participant.
Exactly.
Even if there's a need for a process media knowledge expert, you are expert, but you are within the context of the mediation. You are just a participant, facilitator, onlooker, whatever. You're not, you know, we're not pulling it like you're saying in two different directions.
Exactly.
We're all supposed to be rushing towards the same goalpost.
So Ajay, this is in a way starting from your first oxymoron. It actually filters from there, that once you have created this whole role of the court system, now you're picking up words of the court system and bringing it into mediation, which that parties concept also, which I'm saying that we use it as participants. Parties also, you brought it from the adversarial
But
system.
yeah,
Advocacy also you brought in from the court system. At some point, please just keep them away. This is a different process. Let people understand it as a different process, which I think this connection in every way. First of all, the aspect of mediation, whatever center or whatever you want to do in a court by what you said by
yeah.
itself is an issue. Then on top of that, terminology that you bring in from there, it's not being good for mediation at all.
No, I think that's the chief culprit is that the language is slipped in so easily, and because you have a lot of lawyers that are handling or directing clients to mediation, so they are mixing everything. They are happy to mix up the language. So even the client or the participant is confused because they're like, okay, Mr. Lawyer, is this now part of your office or is this now another process? Because I keep hearing court this, court that. The court has, ordered it, and so even you won't blame the participants if they are confused because a lawyer is happy to bring at least language is happy to bring the court language into the process, but then you got to look at it from the participant's perspective because they want to know, is this now another court situation? Is it another court process? Who is the mediator? Is the mediator the judge? Right? If you
Exactly.
use some empathy and you try to see it from, okay, client is being referred to mediation, how are they understanding? The judge has ordered a mediation. They're gonna it's gonna create. I would be confused because
Absolutely.
I'd feel like, why is the judge ordering mediation? Because I thought you just go to another person. And so, I think lawyers are also partly responsible because they directing people towards mediation from their offices as well. And then they're very happy to mix up the language. And
I
of
did
course,
it.
the participants are sometimes, at least in my experience, they're ignorant. So they're gonna say, "Oh, Mr. Lawyer, you know the terminology. I'm not gonna ask questions. You lead the way." And then of course the whole thing becomes like the lines become blurred like that
Yeah,
through
no, the
language.
interesting thing that comes out from it is that actually there's a particular interview of a mediator from one of our courts in India, and that to the Supreme Court of India, who in his interview says the mediator will decide. The mediator will decide. And he says it 4 times in that interview. So you can imagine,
No.
first of all, you've got the terminology from there. Now you've got the attitude from there. And now you're sitting with people who, for them, a Supreme Court is like, oh, in India, or maybe
Mm.
anywhere else, it's like I've gone to the Supreme Court of India. We as lawyers look at it from our perspective. You have to look at it from their perspective. They're walking into the Supreme Court of India, sent into a room where this lawyer comes in with his gown, because obviously we are still living the colonial world, comes in with his gown and comes and sits there and then says, I will decide. That's the end of the process. You finished it
Uh,
off totally.
yeah, the whole thing about another, oxymoron is that it's a party driven process. So if we are imposing ourselves, lawyers are imposing themselves, court is imposing, saying we are directing the process, then that takes away from what about the parties they want, whether they want to do it or not. Like we don't force people to mediate. Like we can give them the benefits of mediation, but we don't, we say you make up a decision, litigation or mediation. We're not forcing you. But the courts want to be the kind of the, you know, like arbiter or the referee and say, okay, we want to lead a process. We're refusing to acknowledge that this is even a court process. Look, a court process is actually, it's brought by the participants, right? The participants go to the lawyer and say, we have a case, we want to go to the court. So it's not even the lawyer going and like directing people and saying, you must have the case, you must have the case. So it's just, they become too much of a referee or like it ends with us or we have the final say. So yeah, Mr. Mediator, you can do your thing. Yeah, okay, party autonomy, voluntariness, but the decision, the decision rests with us. I think it's almost like bullying, it's like we are, it's a party driven thing, but we want to have the final say. And of course, it's like, that is moronic. You can't, even the mediator can't decide anything. I don't
Exactly.
know. I should have been the interviewer.
I, well, I,
But
be- I, well, actually,
the mediator,
I
yeah.
people send people that link to that interview. because look, I would not put it publicly. I would definitely not put it out publicly, but I do send out that link to show them that everyone talks about two aspects. One is, of course, this court related issue which comes out from that. The other is the aspect of the fact that you think training is doing something. Oh, I will send them a training, their mindset will change. It doesn't change. That's the mindset they have lived with all their life. That's the way they think. And suddenly you think that we'll put them into some training and he'll come walk out into a totally reformed person. It's not happening that way. It's not. So you have to find the people the right mindset, which is what I keep saying.
Yeah, and also you can't, like you're saying, you can't force someone to mediate. You can't force someone to be a mediator.
Yeah, you need the
They can't
mindset.
be changing their caps. Okay, I must take off my gown and my wig or whatever, and then now I become a mediator. You're supposed to be, that thing must always be. So that whole thing about training and certification, you actually you're forcing people to say you have to become a mediator. You have to go along this educational path. And of course, that's the same thing as forcing people to mediate. You can't make. I always maintain, even in my LinkedIn, somebody was disagreed with me. He was more onto the training and the accreditation. And I said, yeah, you do need that, but it's a skills enhancement. It's not you're not installing from scratch into somebody and saying you are now stamped as a mediator, you are approved, you passed, came out of the factory. You might need skills development enhancement, but like we're saying, some people are already doing it. So without all of that, so I won't even say it's a requirement to. You don't need training as a requirement. You know.
So what else? Any other oxymoron coming out? I thought these are going to have a whole list of them which are going to come out. I didn't even think about it. I mean, I actually didn't put my mind towards it. These are going to come out with such interesting ones. I don't even have to think about it.
I think I was gonna go more expansive, but for me, the court situation. That's because up until COVID, and then the rise of online mediation, and then the courts now hijacking mediation, it seems to have come to the fore. So for me, they are the chief culprits when it comes to creating this mutant now. And now we have to work really hard to say, wait, we got, like we say in the language, we got to keep the languages separate, because we're saying, okay, I'm a lawyer. I can speak I can use Latin if I want to. I can mix up, mediation and the court process, and I can tell my client it's one and the same. But of course, I know that it's not one and the same, and we just need, we need to keep the court out of it. Like I said, they taken it and done something with it. They must find a name for that, because it's not mediation. So now our work is cut out for us. We have to, and they are the chief perpetrator. Up until this point, it was not contaminated in the sense. Yes, you have the hybrid forms of, mediation, arbitration, and all those mixtures within the field. But I think for me, the main culprit is the court, and how they've just hijacked it, and the language has even infiltrated some of our circles within mediation. It's just normal, and like you're saying, mandatory mediation, like it's just become so casual. We've accepted it. Wait, so you're telling me that people that come to you you're forcing them? If you're forcing them, then you're not mediating. You're doing something else. So I just think, like for me, I need to, mediation advocates keep the courts, because they've definitely, besides, not just contaminating it, they've changed it. It's not just like more than an oxymoron. It's like they've made it something else. And for the gem of a process that it is, we have to protect it. So I could have made it much longer, but I thought that since the courts have hijacked it so badly
No,
and
that's good to highlight.
mutilated it.
Yeah. No, it's good to
Yeah.
highlight this. This is the one that needs to be highlighted. I think that's what we need to do. I think you brought that out very well. So, Lisa, obviously, first of all, I did every time during that session. It's all recorded. You will see every time I said, Lisa, are you there? Lisa, come in. Before I think 2 minutes before your session had to start, but you did not come in. So that continued. Okay. So it's not that there was any intention to have you wait.
Okay, no, I was watching and I was hearing the Italian and like where do I jump in? But yeah, no, I was here. I was ready.
Great. So now you're coming in tomorrow for the closing session. Please bring out your points of each, if whatever you watched, what you're going to, whatever's come out from them. Because thing is, a lot of people will not be able to watch all of them. So if you give a little gist, at least an interest will be sparked and maybe they'll go and watch it. So that's the idea behind learnings and key takeaways. That's always been the idea, that at least some thought goes out and what you picked up from it, and then the other person who's given that, you've had that session, because everyone can't watch it live, or obviously you'll watch it later. So at least the feedback goes to the other person also who's given that presentation or been part of that discussion as to what you picked up from there. So that's good. And of course, world mediation, this circle has to be discussed, and the skill development project, which you have to be part of, Lisa. Please, have you thought of topics for the for that project? You have to think of topics. Your session will be fixed for that. It's your session. You will happen when you want it to happen. It'll all be done with you, with them connecting with you. I'll put it all out there, and wherever you want me to coordinate, I'm always available. But we'll try to make it in a way that everyone, you can actually connect with people directly. Let them send you a gift. Right now, we're starting with a gifting culture. Let's see how it goes. People appreciate that or not. Otherwise, obviously, there's always an option that Lisa says, I want to charge so much. Finished. That option is the easiest one to do. But if we can do a gifting culture, at least let's get everyone into it. No one should be left out. I will also put out there that, look, if you have any financial difficulty and you can't even send a gift, let me know, which I'll take up with you. So look, so and so has said they can't send you a gift. What do you think? Then it's up to you. You say, okay, not a problem. We'll see.
Yeah.
So that's the whole idea for tomorrow, right?
Okay.
So we are closing the oxymorons. We're not thinking of any other right now. Let's
We're
focus on
closing all the
mediation advocacy.
oxymorons.
We just keep fighting the mediation, mandatory mediation. I think that's going to be a lifetime aspect, because because it's the court's self-interest, they'll keep interpreting it in their favor. They'll go on doing it, because even when they came to the aspect of mediation is access to justice, the discussion came up. Obviously, they went in their favor, because obviously it helps in pushing people to the process by saying there is access, which I wanted someone to discuss that. I had told Nazish that because she is a professor also in law, that pick up whatever you can from everywhere, wherever this discussion is happening. But she wasn't feeling too well, so we let that go. But I think that part also needs to be discussed, because they can't keep getting away with this interpretation over interpretation and taking it in a direction which is, for me, not good for mediation at all. Yeah.
Yeah.
So, Lisa, concluding remarks.
Concluding on the topic.
In general, anything, concluding remarks.
Okay.
This would have been the last session of the symposium, of the conference, but Christina could not do her session. Now, the only space I had was 30 minutes before the closing session. So I said, okay, let's do a 30-minute session. Let's do that. So otherwise, this was going to be the last day.
Okay. No, I'm very, obviously being my first conference, I put myself on the spot, and it's been a very dynamic experience, very nice learning curve for me, and of course, a priceless platform for me to put my little piece out there on various topics. And of course, my my passion is to keep, like I said, keep the judicial process and the mediation process separate, and I'm trying to get that done locally. I even got a call with a student now who's interested in mediation, so that might be our first mediation circle sign up. Fingers crossed. So I'm definitely doing my bit locally, and yeah, I'm looking forward to
Okay.
more involvement and um, collaboration, exposure. And yeah, it's been fun. It's been out there for the world to see and in the archives, and done my part to add to the edutainment section. So
That's what it is.
hope
Everyone contributing their bit and it all developing into how many videos are there now? It was obviously less than 600 when we started off. So we must have done about 60 sessions at least in the conference. At least, I don't know, maybe more. I don't know. I haven't even had a look. Okay, we have 648 videos now.
okay.
Okay, so we've done that much.
Yeah. No,
So that's
thank you. Thank you for, I guess, putting me on the spot and challenging me. So I I'm very grateful for whatever feedback and all of that and exposure and dialogue, and looking forward to more involvement
Yeah. And let's
in the
package it
future.
properly. Let's do the proper packaging of the mediation circle in South Africa. So
Yeah.
I've created that kind of I mean, I was initially, of course, for every country I was creating that and doing it. I said, let's right now just put across the world mediation circle. But I think it's about time now that specific mediation circles that are developing packaging for that has to come out. So one South Africa one I can create, and specific local whatever you want to do, we can create that. Let's put it out in a manner where yes, it's all a kind of a structured approach kind of thing. Let's get people in. Let's have our meetings, discussions, take it forward. Grassroots activity. Let's get to the
Mm.
people. That one question that
Get
I
to the
keep telling
people.
people,
Yeah.
that one question to ask. Let's get those names. Be it
Mm.
local in the local area, could be the national one, wherever it might be. Let's just get those names and let's get those people together. And however that database has to be is going to be created to be available to people, let's start doing that. So that question has to be sent out. So you want me to draft it? All it's simple. Who are those people in your school community who help other people resolve their disputes? That's it. Or their fights in cases of schools. Let's just put it out there. Let's get names.
Yeah. No, I'm posting every Monday, so it's like Mediation Monday. So where I do a little bit of education,
So
slowly, but I'll use those posts to
yeah, no, and then
put out a call.
now we go those WhatsApp groups that people have. Let's send them out there. Look, LinkedIn, the mediation world, of course, is too busy doing other things. Now we have to hit the ground, and for that, those peacemakers have to be identified. Those mediators have to be identified at the local level. So
Mm.
that one question goes out through WhatsApp or emails or whatever. And let's just get even a few names come in. Let's get those people together. So at least that process starts of actually a circle, because the circle doesn't happen until those mediators are not there and the peacemakers are not there. Then we can put it out. Say, okay,
Mm.
this is, I'm saying even a local space, even if a school also is there. So at least these people exist. To put that out, we need those people. So we have those names. We have a little poster kind of thing which goes out with their for pictures and saying that okay, these people are the mediators, and we have to, if we say that mediators and peacemakers, we put it out there. So that little interaction with them will tell us if they are mediators or peacemakers. So all that will has to be done. So let's conference gets over tomorrow. After that, let's focus on this.
Yeah.
Okay. So Lisa, it's been a pleasure speaking to you. And of course, looking forward to lots of collaboration happening.
Yes.